having a conversation about, the environment that we're operating in. So from my perspective, it just needs to be cool for people to see it and then follow along. We just need the cool kids to wear face coverings. I don't know how to do that, but I guess we can get some social media influencers to, put the thing.
We need the cool kids at school to take lead.
That's right. Just wear it. Can you guys hear me okay?
Yeah.
Oh yeah, you could do the whole presentation like that.
That's right.
I think with dealing with the customers too, it's important to keep in mind how you deal with your customers is also to keep your employees safe. So, if you have a situation where you let, all your customers come in without masks, okay, now do you have a risk relative to your employees?
Right.
That's not ensuring their safety.
It's a challenging situation. And
it
so
is.
Signage and all that stuff is important, and doing what we're going to do what we can do. It's just we have new challenges that we've never encountered before.
Right, because it's usually the motto: the customer is always right. You're not.
Well, these are our customers. We're trying to make them happy.
Right. You want to keep your business.
So
that's right.
So for example, one of the things, and the information changes day by day. One of the things that because I guess we're all watching more TV than ever, but one of the things that I saw is that the number one preventive measure is to keep distance and to minimize the amount of time that you spend with people who don't live with you. Okay. And the basic guidelines is 10 minutes. So one thing that you could do is to say, look, if you refuse to wear a face covering in my business, that's okay. But then I'm going to ask you to please spend no more than 10 minutes because I have an obligation to protect my employees. And just let people know, it's like, look, I'm not doing this to bother you or to make you uncomfortable, but I have a duty to protect my employees. So either wear it or be quick and don't spend more than 10 minutes here. And also to make it cool, in the building that I'm at, the last time I came, they had a poster on the door. Today they have like really cool graphics, and they have on the floor, there's a flow line and arrows, because one of the recommendations is for people not to cross each other, right? So to make a one-way, so if you walk one way and you enter, you exit in different ways so people don't cross each other. And at the elevator, there are spots on the ground where you're supposed to stand. So at the elevator, you're supposed not to have more than 2 people in the elevator at the same time. And there's literally a circle where you stand, right? So by using those visual cues, by making it cool, is one way to comply with the duty. So if somebody brings a claim, you can point to all of that as actions that cannot be negligence, and as actions that will protect you from employment claims as well.
Sorry. We can put myself off mute. Are you guys all ready to go? Okay. All right. Well, I want to welcome everybody here. My name is Chris Aiken. On behalf of the Downtown Business Association, we're very excited to start our 3-part seminar series here. The first part here is going to be on the restaurant industry, and it's entitled The Pivot to Dine, How to Reopen Your Restaurant. Next week, as a preview, we will be covering next Thursday at noon, we'll be covering retail. And the Thursday after that, we'll be covering the other business sectors. I do want to encourage all questions from our attendees. The panelists are here to answer questions. And without further ado, I want to introduce our panelists. Our first panelist is Javier Carbone. Javier is a San Clemente-based employment law attorney and workplace investigator, and I'm very privileged to also serve with him on the board of the Downtown Business Association. I'm also very, very pleased to welcome Shannon Wolf. Shannon Wolf is an employment law attorney based in San Clemente. She advises and represents small and medium-sized businesses in employment matters. So I want to do a great thank you to Javier and Shannon for joining us, and welcome. Thank you for being here.
Thank you.
Thank you, Chris. And before we begin, I would like to say that there was a link shared where the materials that we're going to be using in the presentation can be downloaded. Also, I understand that on the chat box, people can go and get a link where they can download the documents if they already don't have them. But during the presentation, we'll be using a few documents which we'll be showing. And let me just begin by saying, I would like to do an introduction by saying that the purpose of this, from my perspective, is to bring awareness to the issues that can become a problem for employers. And this is the goal, that we all have an awareness as to what the legal issues could be when reopening a business. And there's 3 areas. The first area has to do with the health and safety of the employees. In California, employers have a duty or obligation to make sure that they provide a safe work environment to their employees. The second area is just negligence in general. Can somebody sue me if I do something or if I fail to do something? And when we're talking about a lawsuit for damages, the standard is different. The standard is if I did something or if I failed to do something and my actions or inactions are negligence, then I can be liable to someone else. And lastly, there are some laws, employment laws, that are still on the books. The ones that deal with discrimination, the ones that deal with payment of wages, and all of that, they're still in place. So we have to be mindful that we have to continue to comply with the employment laws that are the same, that we have to be mindful that there's a risk associated with just being open, and that there is a risk related to the health and safety of the employees because there's a pandemic, a global pandemic. So if you forget everything we say, just remember this: the closer you are to taking action to ensure health and safety, to protect the public, and to comply with the laws, you'll be in the clear. Because OSHA has announced recently that the standard that they're going to use for inspections is the good faith standard. What does that mean? That means that if you act in good faith, you're going to be in the clear. In that sense, everybody's being more flexible and everybody's just trying to do their best, but it's necessary to do something because doing nothing will put you at risk. Shannon.
All right, a couple preliminary points that I'd like to make is that, first of all, keep in mind there are multiple layers of regulation here. You have the federal, the state, the county, and even sometimes the city. You also have various agencies involved, from the EEOC to the FDA, CDC. I could name a whole host of acronyms. But and how this information can feel like information overload and overwhelming. But at the end of the day, the best rule of thumb and to keep in mind is that you need to follow the most restrictive law. The state sets the minimum threshold, the minimum bar that you need to meet. And if the county and or the city are more restrictive, then you need to follow that. This is also an evolving situation. Each day we're learning new information is being released. So these guidelines that we're going to talk about, they're likely going to change. The orders are likely going to be modified. So you want to stay current. And a couple places that are great to regularly check are the state's website on COVID-19 has a lot of good resources and links, and also the Orange County Health Agency or your applicable county's health agency's website for updated information. With that being said, we're going to start off with the meat of the presentation, and Javier will start talking about the guidance.
Right. So let me just jump into where we're at. Chris, if you can share the slide that we have. It's an image, and it's not ours. It's from the County of Orange. And this is what the County of Orange is telling us, that we are still on stage 2 of the 4 stages of the resilience roadmap drawn by the state government. And on stage 2, the county is asking us to do 5 things. The first one is to do a risk assessment and to prepare a protection plan. What does that mean? That means that we have to go into our businesses, look around, and identify any risk of infection of COVID-19 and to try to eliminate the risk as much as possible. But in order to do that, the state and the county is requiring us to have an actual plan. The second is to train employees in how to limit the spread of the virus. And there are wonderful resources from the state. There are many, many pieces of information that can be shared with employees to help educate them in how to prevent the spread of the virus. The third is to take control measures, which means literally making adaptations to the way we do business, literally means implementing adaptations to change the physical place or the premises to ensure that you're limiting the spread of the virus. The fourth point is to sanitize and disinfect, to clean and make sure that everything's clean. And lastly is what is being known as social distancing, but I like the phrase physical distancing more, because what I've heard is that the number one preventive measure that we can all do is to keep away from people that don't live with us and to keep at least 6 feet distance. So if we maintain physical distancing as much as possible, that is the best way to prevent the spread of the virus. The second is the wearing of face coverings, right? To also stop the spread. Now, Chris, if we can go back to the regular view, the first point is to look at the guidance that has been issued by the state. This is the end-all be-all, because the state of California and Cal OSHA is telling us exactly what they expect employers to do. So if you read this and you follow the recommendations on this guidance, you should be in the clear concerning your obligation to provide a safe work environment for your employees. So please read it, understand it, ask questions, and if you follow these guidelines, you should be okay. But let me just say that in my opinion, if you follow the guidelines to protect your employees, you are also going to be in a position to prove that you were not negligent to any one of your customers, the public, or anyone that walks into your doors, because you're going above and beyond what is reasonable to protect everybody, including the community and the public in general. And once you look at the guidelines and you read the guidelines, what is it that they're asking us to do? Well, the first thing that they're asking us to do is to have a written worksite plan. And there is a checklist, which is another document that we share with you all. This checklist, they have a step-by-step, literally on a check-by-check basis on the steps that are necessary to make sure that we're in compliance with the obligations of the state, that we're in compliance with the obligations of the county. And something that is really interesting, and I want to say now before I forget, is that according to the guidelines, we are supposed to post the checklist at the entrance of our facilities. So my recommendation is that you put this up, and there are simple ways to do it. Just put it up with some tape. I've seen some laminated ones, or maybe we can get a nice piece of wood and just post it. But I think it is important to have it out, post it, because if you put this out and some health inspector drives by and they see that in your door, they're not going to stop. They're not going to start asking you questions. And more importantly, hopefully, people while they're waiting outside in line to come into your premises, they can read it and everybody will be in a better position to follow the rules. But going into the content of this checklist, the first thing that is required is to have a written plan. And the written plan identifies a few things. We have shared with you a model written plan that looks like this. And when you look at it, the first thing that you have to do is just to say that you're committed to preventing the spread of the virus. The second thing is that who's going to be responsible for the implementation of the plan. And what is important about that is that whomever you as a business owner delegate the duty to do this, it can be yourself, or you can ask somebody else to do it. But whomever the person is, that person should be the master of the information and check for new information every single day. Just this morning, Shannon found out that there's new guidance from the EEOC about taking measures to prevent the spread of the virus with people that have a high risk. And that happened between 9 a.m. to now. So the reality is that every single day there's maybe something new. So be mindful that whomever is in charge of this plan has to make sure that they have the latest and greatest information. But once you have the plan, just follow it. We gave you a sample and we like it because we wrote it, but you should do something similar to that or one that is more detailed and better. The second point is employee training. What does that mean? The requirement is to train employees in the prevention of the virus. Well, there are many ways that you can train employees. You can do a formal session in which you talk about preventive measures, or you can do something more simple like keep repeating the same mantra: physical distancing, face coverings, good hygiene, don't come to work if you're sick. If you have symptoms, don't come to work. Avoid sick people, and all of the other recommendations. If I was a restaurant owner, I would give a copy of the guides to all of my employees, and I will ask them to read it. And I know it's boring, but if everybody reads this, they'll be in the same position as the government people who are in charge of enforcing this. So there's no better piece of education than just to read this, to have the employees read it and get ideas and give them a copy of the plan. You see, not only we're giving them what the state is requiring for restaurants in particular, we can give them a copy of our written plan. And with these two pieces of information, that could be enough to comply with the employee training requirement. And finally, and this is pretty unique, the way that we're working is that the state government has a 4-step plan, and the state government has allowed some counties, actually as of today, most counties, to skip ahead of where the rest of the state is at. So Orange County is in an, for lack of a better word, advanced stage 2. But in order to do that, the health officer of the County of Orange has to certify to the state government that certain things are being done. And in turn, our health officer in the County of Orange has required business owners to do what is known as an attestation. What does that mean? It is a certification that you have complied with what the county is asking for, and the attestation or certification also has to be posted in the entrance of the establishment. So we have prepared a sample attestation. This is what it looks like. And you're essentially saying here that you did a risk assessment, that you have identified known risk for the spread of the virus, that you have taken actions to prevent the spread of the virus, that you have trained your employees, that you have taken individual control measures, that you have disinfecting protocols that you clean, and finally, that you are following physical distancing guidelines. With the signature of the business owners, this should also be on the wall, on the entrance, so the county knows that your business is in compliance through the attestation. The next level is to go then deeper into these requirements. What does it mean to take control measures, right? Because the checklist is telling us to take control measures. We have made an attestation that we're taking control measures, but what control measures look like, Shannon is going to help us out understand that.
Sure. So the measures are all safety precautions, and they're broken down into 3 categories, which are the individual control measures and screening, disinfecting and cleaning protocols, and physical distancing guidelines. And so first I'm going to talk about the nitty-gritty details for the individual control measures and screening. The first thing that the guidelines tell you is to implement temperature and/or system screening. Note that it's and/or, so you don't have to do both a symptom screening and a temperature screening, but you have to do at least one. You can do both, but you don't have to. Also, where will that screening take place? It can be self-administered by the employee before they come to work at home. They can take their own temperature. They can assess whether they have any symptoms. Or you can, as an employer, you are allowed, the EEOC has said that it is okay to do a temperature check in the workplace. So you could have employees come to work and have their temperature taken there. You can ask them if they've had symptoms of COVID, if they have coughing or shortness of breath, and do a symptom screen. That can be either verbal, or you could do like a written, like a short written questionnaire. And the guidelines also say that this has to be done at the beginning of each shift. So if you have an employee who's working a split shift, and that means if they're working longer, taking longer than an hour break between their shifts, then that screening, whether it's a temperature and or symptom screen, has to take place again, either through a self-assessment or at the workplace. The second thing is to encourage your sick employees to stay home. Better safe than sorry. If they're sick at all, stay home. And obviously, if they have any symptoms of COVID-19, to stay home. The next is the face coverings, providing them and ensuring that the workers are using face coverings. It's actually required in Orange County. Essential workers must use face coverings, including in restaurants. Gloves, providing and ensuring that workers are using the gloves when necessary, disposable gloves, such as when they're disinfecting and using EPA approved disinfectants. If you have somebody who's conducting temperature checks, they should definitely be wearing gloves. If they're touching any frequently used surfaces. They do specify some certain types of employees that need to use gloves and in what situations. Anybody who is, such as servers or bussers that are moving items touched by customers frequently and handling trash, they have to use disposable gloves. And you also need to provide aprons to them so that they can also change their aprons frequently. And there's a point made in the guidelines to remember that gloves are not a substitute for frequent hand washing. So you don't want to just distribute gloves and call it a day. The employees still need to be washing their hands frequently. And in fact, every 30 minutes, you're required to allow them to do that. The next category they make special note of is dishwashers. You need to not only provide them face coverings, but also provide them with something so they can protect their eyes, whether that's a face shield or protective eyeglasses. Those need to be disinfected between use. They also need to be given waterproof aprons that they're able to change frequently. The guidelines also talk about posting signs. Signs should be posted in the restaurant that are reminding both customers and employees to practice the physical distancing that you've heard so much about. Use the face coverings while they're in the restaurant for the customers and employees. Per OC Health Agency's recent order, customers are actually required now to wear face masks in restaurants. And also including in your signage saying that if they're sick or they have any symptoms of COVID-19, to not enter. The next main category, cleaning and disinfecting protocols. So frequently clean and disinfect. That would include high traffic areas, any frequently touched surfaces, doors, doorknobs, light switches, chairs, anything really, assess the surroundings and take note of anything that's frequently touched between employees and customers. And also cleaning the tables and disinfecting them between customers. And then finally, as I mentioned before, you need to use EPA approved products with gloves to do that disinfecting. And you can easily Google EPA approved products and you'll find a whole list of what's approved. Secondly, you also do not want to share, this is common sense, but just a reminder, not for employees shouldn't be sharing any PPE. They should avoid sharing work supplies to the extent possible, like pens or tablets or anything else. Have hand sanitizer. Have that available for your guests and your employees at the entrances. Also have it available in areas in the restaurant where your staff are assisting customers frequently, like at a host stand or other areas where they're having a lot of contact. It also talks about circulation to the extent when it's possible, if you can open doors or windows to increase circulation. They say to check your ventilation systems and air filters. You're not required to, install the newest and latest ventilation system, but, I'd recommend you check them, make sure that they're, in working order, check and change your air filters. if necessary. When it comes to menus, they recommend disposable menus, but if you can't do that, then the menus actually need to be disinfected between each customer. The tables, they have requirements as far as do not preset tables, no items on the tables, providing, such as for condiments, if you can provide single use, if you can't, to disinfect between use. As far as utensils, you are to pre-roll them in napkins and store them in a clean container and only put them out after the customer sat down. As far as any kind of after dinner type refreshment or mints, don't have the bowl available up front. It should just be provided with a check if you do that. Of course, clean and sanitize utensils between customers. If you're using reusable utensils, and they ask that you consider using disposable items. Any takeout containers have to be filled by customers. If you're using linens, they need to be removed after each customer use, and they go as far to say is that those need to be removed by an employee that's using gloves and taken away in a sealed bag. If you have any common use areas like a soda machine, like ice cream, self-serve frozen yogurt, or a buffet or a utensils area, any kind of common use areas, those should be closed, and you should have other alternatives. And then if you have any sort of shared entertainment areas, such as video games or pinball machine or some kind of thing like that, those areas need to be closed. And then finally, the physical distancing guidelines. The first sort of main topic is limiting traffic inside the restaurants. And they ask that you prioritize outdoor seating and curbside pickup. They want to avoid having people hanging around inside the restaurant, really encouraging your customers to make reservations. I've seen restaurants that have reopened doing that. And then if you get a walk-in person, rather than having them wait for a table inside, asking them to return at a later time, a table will be ready, or calling them when a table's ready, calling them on their cell phone to let them know. Basically take measures to just avoid having people hanging out inside. Also taking measures to encouraging physical distancing by providing visual cues like floor markings, letting know customers where they should stand, and signs encouraging physical distancing. Look at reconfiguring your space and removing tables and chairs where it's possible. So if you have tables that, where people are closer than 6 feet, consider moving your tables and chairs or removing some. Where physical distancing is difficult, they suggest installing some physical barriers. I'm sure you've heard of and seen the plexiglass at some places, especially where it's hard to maintain distance, like at a cash register or a host stand. As far as training employees, they suggest holding those trainings virtually when you can, or if you're going to do it in person, to make sure that it's in a manner that respects physical distancing and safe. They also suggest staggering employee breaks so that you can avoid, employees congregating. Any bar areas must be closed. And then when serving customers, they want you to limit the number of employees that are serving the same party, and to only seat a party when everybody is present. So wait till the entire party is there and then seat them. And then finally, only seat people together that are from the same household or who have requested to be together. So don't combine people that don't want to sit together. That's pretty much common sense. Finally, the guidelines refer to some other published guidelines by the FDA, Cal OSHA, and CDC. There are links in there if you access the guidelines online. I would suggest starting with the FDA's on food safety. First, Cal OSHA and the CDC guidelines, there's a lot of overlap with what we've discussed today. So first I would start with the FDA. And now we're gonna talk about the employment law considerations.
Now, before we switch to the employment law, because we are employment lawyers, so we can spend all day talking about this. But I want to take a step back Shannon, and I think I heard you say that when we talk about screening, right, of employees, their requirement is to do one of two things: to either do it by temperature check or symptom screening, one or the other, right? So my follow-up question is, what do you recommend the best way is to screen employees? And the same question about customers. Are we going to screen people who walk in the door?
Those are both very good questions. So one of the issues with screening, which I was going to talk about later, but we might as well talk about it now, is the time spent screening is compensable. So the employer does have to pay the employee for the time that they spend doing a self-assessment or doing the screening at the workplace. The other issue to consider is if they're screening themselves at home, then the thermometer technically is a business expense. And it's something that you're telling them they have to use a thermometer to check their temperature. Some people don't have thermometers. Anyway, it's better safe than sorry. It's a business expense and you do have to cover it. So those factors you might want to keep in mind deciding what to do. You know, I think that you could do it either way. I think that a self-assessment is fine. Or you could have, you know, it depends on what you're comfortable with. You could just do a simple temperature check. You could maybe do both. Have them do their own self-assessment at home and ask themselves, do I have any symptoms? And don't come in when you have a fever. And then when they come in, also do a temperature check. You could do that.
Now, so if you ask employees to do the self-assessment at home, would you ask them to sign something at the beginning of the shift that they have self-checked and they're ready, willing, and able to work? Or just saying that they're just showing up is enough?
I think just showing up is enough. Obviously, you could document your way every step, you know, if you wanted to be super cautious and you had the time to do that. I'm thinking practically if you're a small business, you may not have the time to do all that. And if you do document it, you need to keep that private. So if you do want to document it, you can have them do that. And if you're recording their temperature, if you're taking their temperature and then you're recording, that's also considered medical information. You have to make sure to keep it in a separate place that's protected, their privacy is protected, and you're not exposing their personal information to other employees. So if you're going to do any kind of screening in the workplace, you want to be mindful that you're also taking into account their privacy.
What about customers? I mean, the first time somebody put a temperature gun in my forehead, it was weird. So are we going to do that? I mean, do we have to?
Yeah, I haven't personally experienced that. I've seen in the news, some restaurants have done that. You don't have to do that. I mean, my interpretation is you don't have to do a temperature check of your customers. However, if you're not going to do that, you should at the very minimum have signage that says, if you have a fever or you're sick or have any symptoms of COVID-19, do not enter our premises. You could also ask your customers if you wanted to. Do you have any symptoms of COVID?
Now, before we move into the employment law section, I think there's something that we need to talk about, and it's about face coverings, right? If I read the guidelines, and it seems that client-facing employees must wear face coverings. Servers must wear face coverings, and the guidance said that customers have to wear face coverings. Well, gee, if I go to a restaurant, I'm gonna eat, maybe drink, but the reality is that I cannot do that with a face covering in place. So maybe one way to go about it is to say, well, why? As long as you cannot keep 6 feet of distance, you must wear it. So between the entrance and the table, they should wear it, clients, customers. What they're eating, it's no way to do that, but once they leave, they should. So maybe making clear that the expectation is that where you're eating or drinking, you don't have to wear it, but if you're not eating and drinking and you are within 6 feet of somebody that doesn't live with you, you should wear a face covering. That's my interpretation of a way to implement the guidelines, because the guidelines suggest that people have to wear them at all times. But the wearing of face coverings has become, in my opinion, unnecessarily political. And that is a reality that we have to deal with because some people are going to refuse to wear face coverings. So in those cases, what is a business owner to do? And of course, I'm going to ask the difficult question to Shannon, and then I'll give my opinion.
Well, yeah, this one is really tricky. First of all, I think, through the signs, really encouraging and showing through your practice that, look, all of us wear face coverings. So, it's not a big deal. You can do it too. You may get that customer who says, I have a condition. Well, if they have a condition, they can't wear a face covering, then, you may make an exception there. But I think this is a balancing test. I think that what you want to avoid is basically where you've just got a bunch of customers that are coming in and not wearing face coverings at all. I agree with you. Of course, they can't wear face coverings when they're eating and drinking. If they're sitting at the table without face coverings, I don't think that's as much concern. When they're coming in and exiting, I think that's a good line to draw that you're suggesting, Javier. I think the other importance is to remember that you're also ensuring your employees' safety by requiring the face coverings when they're in the restaurant. And if you tell your customers that this is for your employees, and sometimes, when people hear this is to help others, it kind of like brings their guard down. But, I understand it is a very difficult situation and it has become very political.
Right. So now that you gave your perspective, what I'm going to say and add is that I think that one way to deal with it is to have people become aware of the need for face covering. And this is what it looks like. Because as a business owner, I have an obligation to provide a safe work environment for my workers, and the state and the county is requiring face coverings. I would talk to the person and say, look, I am asking you to please wear a face covering while you're walking inside my premises to protect my workers. Could you please do that? Because it is a requirement from the county and the state. And if they say no, great. But let me tell you that the science says that physical distancing is the number one way to avoid the spread of the virus. And the number two is the amount of time that you spend close to somebody that doesn't live with you. So, and the guidelines say that it's 10 minutes. So I would say something like, look, if you're not going to wear a face covering in my business, I'm going to then ask you to spend no more than 10 minutes. Can you meet me there? Can you do that? And then just kind of kick them out in 10 minutes. And if they refuse to do that and they want to stay because they're freedom fighters, well, look, there's not much we can do about that because the sheriff already said that the sheriff is not going to intervene. But another thing that we can do is just to make it cool to wear face coverings. And I don't know, maybe get some influencers to make it cool, or the county is trying. For example, you see this visual cues. There are posters and there are things that the OC Health Agency is trying to do to ensure that people wear face coverings in public. And maybe we can make posters like this and put them everywhere. And one analogy that I like to use is the smoking section. When I moved to California, everybody was smoking everywhere. And all of a sudden, now people are smoking in designated areas. So designating something, putting visual cues, asking people and putting posters, it works. So maybe we need to just patiently wait until it becomes cool to wear face coverings, right?
Yeah, let me kind of add something here too. There's a couple questions from the attendees that I'd like to get your guys' comment on. First question is, have there been any rulings on permitting outdoor patio service in Orange County or any cities in Orange County? So can you make a comment on outdoor patio service and what your understanding is there at the present time?
Shannon?
Well, I mean, the guidelines say to encourage outdoor seating. Now, as far as any city regulation on whether you can use certain areas and how much, I am not familiar with that. I am not an expert in that area, so I do not know.
Right. So the same guidelines apply regardless of indoor or outdoors. Mm-hmm. It's just that outdoors is much easier to keep physical distance. And because it is open, it is much easier to allow people not to wear face coverings, and there's more flexibility. This is a question of use. Can you use the sidewalk? Can you use the middle of the street. So some cities are taking action, and it's public that the city, as I understand it, only um, San Clemente, my understanding is that has not done anything, but Fullerton has. So this is like a city by city permit thing. Um, I think it would be a good idea for the local authorities to allow business owners to use a public space for their business, because that will help prevent the spread of the virus. And quite frankly, we're thinking about the obligation that we have as business owners to employees, the obligations that we have as business owners to the public. But the flip side of that coin is the public. Some people are afraid of going into indoor spaces. Some people are scared of leaving their house. So the more that we can ensure physical distancing, the more that we can ensure that we're following the guidelines, the better it will be for people to trust your business and go spend money, which is at the end of the day what we're doing, to make sure that people feel safe and then they can come back. Now, I think it's time to switch to the employment law perspective before we run out of time. You know, Shannon and I can be speaking about this for a couple of hours, but we only have one. So let's just jump into it. Chris?
That's fine. Just one more question, because I happen to see it. And maybe you can use, as you know, I'm a part owner of a restaurant. We have a patio. We also have a bar. Using that as an example, for instance, the question is, what are the guidelines for seating at a bar and a restaurant? And do you have any comments? And I talked to you guys, an issue that we have, what's our duty as a business owner, restaurant owner, to, I guess, police our patio for social distancing there? So maybe you can comment on that, and maybe you can turn on to the next topic. That would be okay.
Yes, Shannon.
So the guidelines say to close bar areas. It doesn't get any more detailed than that. It just says close, basically close bar areas. Now, if you are going to use a bar area for people to have meals, then of course make sure that they're 6 feet apart from anybody else. Make sure they're appropriately physically distanced, and that you're taking all the other safety precautions in using them. And then the other question, as far as, sorry, I forgot what your other question was about.
It's the patio area. So for example, if you have a patio area,
right,
from my perspective, one good idea is to use visual cues for people to keep physical distancing. So for example, I would make it with, tape or something more permanent, to make it like a chessboard and say, keep clear, or stand here, or some way, or draw circles. I saw a circle that is 6 feet wide, so people can say, okay, I can stand in this circle and I'm going to be away from other people. So as long as people who live together, they can be within the circle, but keep at least 6 feet for people that don't live with you. That should be one way to, even in an open or patio area, to ensure physical distancing to prevent the spread of the virus.
Right, and you can even, if you have tables on a patio, you can even block off tables, or put a sign, no one sit here, to keep people distanced. But I agree with Javier, having lots of signs. And if you see people congregating out there, an employee can politely go out there and ask people not to congregate there.
That's right, and I know we're moving on, Javier. We'll do that, but I do think there's an interesting comment that's right from one of our attendees, that to take note that in Costa Mesa, Newport, Huntington Beach, you still must get an ABC permit to extend sale of alcohol to expanded spaces, and that's an area I know that's developing, because obviously we can do alcohol to go, but how that looks and how that expands to outdoor sips, you still got the ABC. So I just want to be mindful of that for restaurant owners out there. But
highly regulated, no doubt. And those regulations have not changed. My understanding is that they're in flux, but they haven't changed. So it's very strict.
They're not discretionary. So make sure you know your ABC rules, make sure you know the state, and because there have been some local jurisdictions that we know here, even in San Clemente, that have gotten some flack from ABC. Anyways, so Javier, you guys want to get to the employment law?
Right. So in the time that we have left, from my perspective, one thing that is important is to update your policies. What does that mean? Well, the first thing is that because this pandemic is a health and safety issue, we have to make sure that we have health and safety policies in place. Every employer in the state of California is required to have an injury and illness prevention program, right? And we all have one, right? And this is where you shake your head up and down and you say, yes, I have one. So just in case you don't have a written injury and illness prevention program, we have given you a link to the e-tool that Cal OSHA has. And if you follow the e-tool and you answer some questions online, the system generates a sample of what an injury and illness prevention program looks like. The reason why we don't have a sample in writing is because the risk factors change depending on the business. Some businesses have risk factors that other businesses don't have. So my advice is that get an IIPP today. In addition, prepare a policy today. And if somebody shows up to do an inspection, just keep them in a binder and show them what you have, right? The second is that the federal law requires, the new federal law, the Families First Coronavirus Response Act requires for the posting of a notice concerning emergency paid sick leave. Just make sure that is up and then you give a copy to the employees. And this is the time to be flexible and very nimble when dealing with accommodations and requests for time off and all of that. So our policies now have to be, maybe we don't need to change them in writing, but we definitely have to change in the implementation because this is time to be super flexible, maybe bending over backwards to avoid potential claims. And with that, I think, Shannon, we should talk about rehiring and bringing people back.
Yes. So the first question is, who are you going to bring back? You may not be bringing back your entire workforce, or you may not have the need to bring everybody back. So the key is to use whatever criteria you use, however you're making those decisions, to do them in a non-discriminatory manner, and just make sure that you're using some kind of neutral criteria or some kind of criteria that's really related to a real business need. So I mean, some criteria people use are employees who've been with you the longest, who's been employed with you the longest, something like that. And then also make sure, take a look at who you have selected to come back and make sure it doesn't look like it's discriminatory, because, if it turns out, oh, you're bringing back all the males, but all the women, they're not coming back, well, that could raise some eyebrows. You might have some people who don't want to come back. They might not be comfortable. And our recommendation is that, you tell them, look, we're taking all the safety measures and precautions, we're following the state's guidelines, but if they still are uncomfortable, to just respect that, don't pressure them, and just let them stay, off work, or if they've been on a leave, just let them stay on a leave. I wouldn't recommend terminating them, not during this time, just let them stay on that unpaid leave.
Now, Shannon, let me stop there, because we're talking about what are we going to do if somebody doesn't want to come back, right? And there may be some legitimate reason for the person not wanting to come back. We don't know, and frankly, we're not going to ask. But I agree with you 100% that we have to communicate that we have taken the measures to ensure that the workplace is safe, and ask them, could you please come back? And if they refuse, what I would do is to document that. So I will send them a letter to document that we advise them of the measures taken, that we offer them to come back, that they refuse to come back, and then the question is, now what? Technically, you can terminate their employment. This is an employment at will state, and you can fire them for not showing up, but that is risky. So what I would do is just to tell them that until they come back, they're going to be on a furlough, and that's it. If and when they come back, then if we have a position available, we'll take them back. But the reason why I suggest that we put it in writing is for two reasons. Number one, we want to have some evidence that we told them the measures that we took to make the workplace safe, so it is up to them to come back. And number two, and this is a complication that we were going to talk about, is that according to state rules, after 10 days of furlough, you're technically terminated. So a furlough can become a termination after 10 days, which is super weird, but that's what the law says. So the employment relationship may end anyway, even if we don't want to. So be mindful that you may have to talk to your payroll people to issue a final paycheck if somebody refuses to come back. But I agree with you 100%. I'm just saying, let's just document that for whatever reason the person doesn't want to come back. And before I interrupted you, I think that you were we're going to talk about accommodations, right, Shannon?
Yeah, I was just going to mention that, there may be employees that have a disability, or that they're in the high risk category. They may have some kind of condition that puts them at higher risk of contracting COVID-19. And so you can't, on that basis in itself, you can't refuse to return them. So I wouldn't, try to play doctor and just decide you're not going to return any of those people to work. But if you're concerned about their health, you can ask them. The ADA says you can ask them if they need some kind of accommodation to return to work. And, of course, that would be flexible, and see if you can provide them some kind of reasonable accommodation, whether that be doing the type of work that limits their exposure to customers. If you have any sort of administrative work that can be done remotely, those type of things. So although the ADA doesn't mandate that you ask people if they need accommodations, you can ask your workers generally, if you need accommodation when you return, please let me know.
And who's at a higher risk?
Well, anybody with an immunocompromised condition, people that are 65 or older, and I believe also pregnant women have been in that category. You can go to the CDC website and they will list all the people that are in the higher risk category. But again, when you're doing that return to work, you definitely don't want to just single out all your older workers and refuse to return them. If anything, if you are concerned about returning them, ask them if they need some kind of accommodation.
And this is the tricky part, because we cannot discriminate. And if we know that somebody's over 65, if we know somebody has a critical or a medical condition, we shouldn't use that as a factor to bring them back. But when they do, then we have to accommodate and we have to protect them. So this is kind of like difficult to have those balancing interests that they may clash. And what we're saying is just be careful, because you have a duty to protect them, but on the other hand, you have a duty to allow them to come back, which then takes me to the next item that we wanted to talk to you all about, is the leaves, right? The first one that I want to mention is the Families First Coronavirus Response Act, which provides up to 40 hours of emergency paid sick leave. The emergency paid sick leave is under a special federal law that is available until the end of the year, December 31st. So it is important to know that that law is still on the books until the end of the year. And there are essentially five qualifying conditions to take that special leave. And one of them is when children are not in school because the schools are closed. Now, the school year is almost over. But the reality is that between now and December, there may be some people who may qualify for emergency paid sick leave because of the situation with the children being in school. And the rate of pay changes depending on which of the five conditions qualifies a person. Some of them are full salary, some of less than full salary, but that's the federal law. It's important to be mindful of that. Separate from the special emergency paid sick leave, California has a paid sick leave law, and people get at least 24 hours per year for paid sick leave. So if somebody wants to take paid sick leave because of a COVID-related reason, we have to know and be aware of that. And finally, the FEHA, the law that prohibits discrimination in California, requires a reasonable accommodation for people who have a medical condition and they cannot perform their duties without an accommodation. What does that mean? That means that we have to try to find a way that is not an undue burden to accommodate somebody for them to do the work if they can. And I saw a published report of somebody who said that they could not wear a face covering because of a respiratory condition, so they were not going to wear a mask. If we have asked employees to wear a mask and the person says that they can't, what are we to do? Well, what the law requires is that you engage in an interactive process to try to find a reasonable accommodation. So using that example, if there is, as you mentioned, Shannon, a position for the person to do a work that is not client facing, that may be reasonable because if you're not facing the client and you're in the back of the house, maybe you don't need to wear a mask. But if we absolutely cannot find an accommodation for that person and the person cannot work remotely, then maybe it is undue hardship. All I'm saying is that those areas have to be balanced, and this is all gray, and just be mindful and be careful because the laws are still in the books, and it's the duty of the employer to provide an accommodation in those cases that are necessary. Now, something that is close and near to my heart, wage and hour issues. So let's talk a little bit about wage and hour.
Sure. So when you're bringing your at least your hourly employees back, there's some wage and hour issues that you should keep in mind. So the time spent that the employee is spending, putting on any protective wear, their masks, their gloves, anytime they're cleaning the restaurant, doing those type of duties, hand washing breaks, all those extra precautions that they need to take and that you're going to train them to take. That is all compensable time. So you want to make sure that you are not considering that non-work hours. You want to make sure that they're getting paid for that time. And that also includes, the screening check. And then if you have an employee, let's say, come to report to work, and then for whatever reason, let's say you don't have enough, the schedule changes, but they were scheduled to work a full day. Well, if you tell that employee, you tell them you don't have work for them, they need to go home, they can't work, then there's something called reporting time pay, which you may have heard of, and then you would need to pay them for half of the time that they were scheduled to work, a minimum of 2 hours and a maximum of 4 hours. And then for salaried employees, let's say you have somebody you've classified as exempt, some kind of managerial employee. If you did give them some kind of pay reduction, you just want to make sure that if you're still classifying them as exempt and not paying them for overtime, that you still meet the minimum requirements. Any exempt employee has to be paid a minimum salary. They have to be salaried, and the minimum salary is twice the state's minimum wage. So if you've got 25 or less employees, that exempt employee needs to receive at least $49,920. You have 26 employees or more, the minimum salary is $54,080.
No matter what.
No matter what. And then you also want to make sure that their duties, that they're still doing actual managerial work, that, if they're basically just another server and not, doing any management type duties anymore, then they have lost the exemption and should be classified as hourly. So you just want to be careful if you are making any changes in pay or duties for those managerial employees. And then the last thing is the business expense reimbursement, which I had touched on earlier. The face masks, any type of protective equipment that they're required, if the employer is not going to provide that equipment, let's say they're picking out their own face mask, then you should reimburse them for that. And make sure that they're getting covered for that. And then also the same, if you're having them do temperature screening at home, you should reimburse or provide thermometers to them. And it may seem like a small thing, but these type of wage and hour actions can turn into big problems. Javier can expound more on that. There's something called PAGA in California, which is the Private Attorney General Act. And basically an employee can bring claims on behalf of all other employees as well. And it's like a class action, except there's a lot less requirements for the plaintiff to meet in order to proceed. So that's just something to watch out for, and just take those business expenses seriously.
Right. So I have a couple of follow-up comments, and one of them has to do with the face coverings. I agree with you, Shannon, 100% that if the face covering is required, it is in the best interest of the employer to pay for it. Maybe the employer can buy them in bulk and make it easier. But if you're not going to do that, then be mindful that, as with uniforms, right? Every time you require a specific type, brand, or something that is, they all have to be the same, it becomes a uniform and you have to provide and pay for it. It's like the shoes, right? If you wear non-slip shoes and they have to be black, I don't care what brand, that's not a uniform. But the minute that you say that all the masks have to be the same or a specific brand, that may become a uniform, and it's definitely reimbursable. I mean, maybe this is the time to look to do branded face masks with your logo of your restaurant. I don't know. Just be mindful that that is an area of concern, because like Shannon said, there's some PAGA attorneys out there chomping at the bit to bring a claim. And concerning salaried employees, restaurants should not have many people on salary. Should very few, especially in the kitchen, maybe one or two people can be on a salary, because misclassification of restaurant employees as salaried is an issue that was there before the virus. But I say all of that to agree with you, Shannon, that if, for example, you ask a salaried employee to do physical tasks and they end up spending more than half their time doing physical tasks, they may lose their status. So if you're going to ask your salaried people now to help clean and disinfect, be mindful that they don't spend too much time doing that. And about the hourly employees, I just want to add that the time that it takes for them to wash their hands, the time that it takes them to put any kind of covering or apron, gloves, cleaning or disinfecting is all compensable to the last minute. So be mindful that this is a time to be super flexible with when people are coming in and leaving, and however long it takes them, they're on the clock. Make sense?
It does. So just a couple things. I have a question and a comment. One, I want to thank the attendees for some very good thoughts. They have been providing some information as it relates to that there is a clear permit process through the ABC as far as serving adjacent to your restaurant. That's kind of going into effect, and it does have a cost. So find that at the ABC. The question I've been curious about listening to you is, maybe Shannon, you addressed this earlier. If we have employees at the restaurant, for instance, are you saying that what rights do we have as an employer to ask them about their health? I know there's your typical right of privacy to medical information. So I'm just curious, how does it work now in the COVID world? And what rights do we have as business owners to ensure, they ask them for their health status so we can protect all our employees?
Yeah, so you can, the EEOC has said you can, if you want, you can require people to take a COVID test to return to work. You could do that. I don't think this is a time now to ask all your employees, okay, now you need to disclose all your disabilities. That's
right.
That's not a good idea. If you know somebody where it's obvious, somebody, it's just obvious that they fit into one of those categories, and you have some information, they've disclosed it to you. You can ask them about, if they need an accommodation. You can even generally ask your employees, all your employees, hey, does anybody need an accommodation? Does anybody have need to request an accommodation? But I would not suggest prying into all your employees' medical information, asking them, what conditions do you have? You can ask them COVID-related things. You can ask them if they have a fever, if they have any of those symptoms, chills, muscle pain, shortness of breath. You can ask them all those things, but I wouldn't try to find out every condition under the sun.
Okay. I know we're kind of running out of time. I guess any final comments, Javier and Shannon? I will tell you again, kind of to remind everybody, this is the first part of a 3-part series. I know next week at noon, you guys are going to be talking about how to reopen retail, and then the other businesses will be a week after. So I want to preview that. That can be found at the San Clemente Downtown Business Association website, and obviously the publications will get that information out. Just contact us if you want that. But before we kind of conclude, any other final comments or anything else you guys would like to talk about?
Well, from my perspective, I'm going to make myself available to answer any follow-up question within reason. If there's a question, I'll be happy to answer it. But of course, the idea is to give information that you can use, and I'll be happy to do that by phone, by email, whatever makes sense. But when you participate in a webinar like this, you may be kind of concerned that there's too much and that there's a grave risk. And I want to finish by saying, all we need to have is awareness that there are risks out there and we have to manage the risk. So if you are aware that you have a duty on the health and safety front, you should take actions to protect and manage that risk. If you are aware that you have an obligation towards the public, which is less than the duty to your employees, you can take actions accordingly. And finally, all the rules about payment and accommodations and all of that are the same. So there's really nothing new concerning the wage and hour, the job accommodations, and all the employment laws are still in the books. Now, the implementation is more flexible, right? Because, for example, medical inquiries were a no-no. You were not supposed to do any medical inquiry. And what the government is saying is like, look, we have a global pandemic, so this is the time to ask about COVID-related conditions. You can absolutely ask about COVID-related conditions. But the minute that you step out of the pandemic and the virus, it is dangerous to ask people if they have a medical condition that prevents them from doing their job with or without a job accommodation. So there's really, we have already covered what is new, and just be aware. And like the airlines say, sit back, relax, and enjoy the flight. Shannon.
Yeah, I just wanted to thank everybody for attending. And like Javier, if anyone has any questions, feel free to give me a call or email me, and I'll try to help you or point you in the right direction. And thank you, Chris, for having me.
Well, thank you, Shannon. Thank you, Javier. And thank you for all our attendees to coming in our first part of the Reopen the Restaurant webinar. We really appreciate it. And thank you again, panelists. And we will see you again next week. Thank you.
Thank you.
Bye now. Thank you.